I'm Chris McDonough, a retired homicide detective. I've interviewed thousands of people, from serial killers to ministers. Welcome to the interview room. Aloha, everybody, and welcome to the interview room. Wow. I got to adjust my seat. This case, the Suzanne Morphew case, has taken another twist. I want to thank everybody for being here this evening. Got a special guest with us tonight. And before we get to him real fast, I just want to thank our mods, Miss Sophia, Maui Girl, Mimi J2, Stephanie Urban, Teresa Milligan. Without you women, we cannot make this show possible. You are absolutely amazing and the best on YouTube, and quite frankly, the best in the business for doing this. You've taught me so much, and our family will be forever grateful for everything that you have given us and showed us. Well, tonight, I got to be honest with you. I've got one of the, in my opinion, and I've been around this industry for over 40 years, just coming up, actually. Started in 1982, and here we are coming up in 2022 here. August will be 40 years for me. And in that time, I have met some really bright legal minds. I've had the privilege and the honor to sit next to them in trials and courts. But I got to be honest with you, I've watched this good friend of mine and in the courtroom. And let me tell you something. You do not, repeat, do not want to be on the other end of what's coming downstream. He's one of the brightest legal minds in criminal law, in my opinion, in this country today. You've seen him everywhere on media programs throughout the United States. He jumped in early in Maya Miliete in San Diego, and it was because of him, quite frankly, assisting and putting the puzzle together that law enforcement was able to make some great strides. And that's what it's about in our legal system. And without further ado, I'm going to introduce you, if you're new to our channel here, to Mr. Billy Little. Billy.
Hey, Chris.
Hi. How are you, buddy?
Good, man. How are you doing?
Good, great. Thank you for being here. And for our viewers, if you would just hit that subscribe button, that's all we ask here. And then keep our chat classy, because we're going to talk very seriously about Suzanne Morphew and her ex-husband, Barry. But that said, I want to tell you a little bit about my buddy here. Billy is a recognized capital defense attorney. In fact, he was not only worked on the defense side, but he also did a lot of prosecution side too. So he goes in every direction that the truth points him. He served in the military, and the last time I forgot to say, Ura Semper Fi, because he was a military officer, not only in the Marine Corps, but ultimately ended up getting out after retiring from the Air Force. And in that time, he was the Deputy Chief Defense Counsel for military commissions. He was responsible for representing death penalty cases and actually tried 17 capital murder cases. And his track record speaks for itself. He didn't lose. Actually, you lost
Well,
one. you, you lost one, but we're not going to hold you to that. He was infamous for the Iraqi honor killings, where a client who was a lost boy of Sudan, it was a suicide by cop, right, Billy?
it's now you've got three of the cases kind of mixing together, but I did all of those. I did Iraqi honor killing, suicide by cop, uh, lost boys of Sudan. Yeah, I've done one or two cases that are interesting.
Yeah, and you actually have dealt with the most difficult clients who are suffering from mental illness and a variety of other disabilities that really made it difficult in the courtroom, but you were able to navigate all of those moves and had successful outcomes. You were also, let's see, you were an administrative law judge for the state of Arizona. So the reason I asked Billy to come on tonight is obvious. If there's anybody that knows what this motion to dismiss means from both the prosecution and the defense position, that's my buddy here, Mr. Billy Little. So let's show them where you guys are at here. Kind of chime in, tell them where you are. We've got folks from, let's see here, the Netherlands are over here, France. It's they're coming in, Billy, from all over the world to hear you tonight. The UK, Lynchburg, Tennessee. This is amazing, and Australia, Scotland, Norway, North Carolina. The amazing part about the internet is it is international as a whole. The power of this platform, and we take it very, very seriously over here in the interview room. Ireland is in the house in Michigan. We'll be in Michigan in a couple of days. So
Yes, we will.
We can talk about that one later. But okay, so first, let's set the stage here. Right, Bill? We've got this wonderful human being, this mom, two daughters, rough marriage, things going sideways. It looks like, she disappears. The husband says she went out on a bike ride. The cops say, okay, well, we're going to investigate all of that, and then subsequently end up arresting him for a variety of reasons, mostly pretty much circumstantial in nature, and because they have not found her remains to date. So it goes to initial, hearings, things. Explain the process of some of these pretrial hearings. What exactly goes on there, and why are they so important and necessary?
Okay, so I'm assuming that the people who are viewing now realize that Mr. Morphew's case has been dismissed without prejudice, meaning they can refile the charges. But to get to this point, we got to back up about a year and a half. So Mr. Morphew was arrested and charged with murder. And depending on what stage, and this is going to be very technical. So if people, if I say something and it doesn't make sense or you don't understand, just shoot a question real quick on the screen and I'll explain it. But when you're charged with murder, a lot of times a prosecutor will move to have you held without bail. So when you do that, the defense is entitled to have what's called a proof evident presumption great hearing. Most attorneys do not file that motion, but for strategic reasons or tactical reasons, it's a very good motion that's filed by the defense because it will expose the weaknesses in the prosecution's case early on. So in this country, because I know people are all over the world, we have different standards of proof. So to get an arrest warrant, you need probable cause. Probable cause is 51%. So 51% to get a search warrant, to get an arrest warrant, you have to show a preponderance of the evidence. That's 51%. So above that, let's say they want to take away your children. You have to show clear and convincing evidence, which is, there's no number on it, but it's higher than preponderance. So it's higher than 51%. To get a conviction in a criminal case, you need beyond a reasonable doubt, which is our highest standard. But if you want to take away somebody's freedom for the purpose of holding them without bail, there's something that's below beyond a reasonable doubt, but above preponderance of the evidence. And it's kind of mushy in there somewhere, but it's a pretty high standard. And it's called clear and convincing. No, it's called proof evident presumption great. There's not really a number you can put on it, but it's proof evident presumption great. And so what the prosecution has to do if they want to hold somebody without bail is prove with proof evident presumption great that that person committed the crime that they're charged with. It doesn't mean that they're going to dismiss the charges, because there's still a preponderance. There's enough to get a warrant to have them held and await trial. But if you want to hold them, thanks, Ruth, hold them in custody until the trial comes, which can be a few years for these murder cases, you have to meet that standard. And so what you really have to do as a prosecutor is kind of lay out your case, which gets the defense an opportunity to see what evidence you have, what you can do. And the prosecution, they don't want to let this person walk free because they believe he's a murderer, he's a danger to society. So they want to put up their best foot forward. And way over 90% of the time, that standard is met by the government. They can meet that standard. And because the court also wants to protect society. And when you don't meet that standard early on, when you don't meet the standard of proof evident presumption great standard early on, that tells you there's a problem with the case, at least in that judge's eyes.
Okay, so I want to stop you right there for a second, because I want to explain to everybody a couple of also technical issues for tonight. So I see everybody's super chats, and I see everybody's some have questions on them. So I am flagging those. So we're going to get to them. I promise I'm not going to miss them. Billy will answer those. And I see a couple of, a few in here. Why did it take so long? So we will get to those. I'm flagging them. I wanted to give everybody a heads up. And so I'm sorry, Billy, I wanted to get that out of the way administratively, so that way folks, when they're listening to you, can focus on what you're talking about. And then we'll come back to the Q&A where you can answer those questions for them. Is that cool?
I appreciate that, Chris, because I do I'll get taken off course pretty easily if somebody throws a question out there. Yeah. I'm easily distracted. I am a man, so I'm easily distracted.
Exactly.
So
okay.
At this hearing, at this proof evident presumption great hearing that was held last year sometime, the judge found that they didn't meet the standard. Well, there's a red flag. Okay, prosecution, unless you're holding back some big evidence, which you probably shouldn't if you don't want to let people out on the street that shouldn't be out there. Unless you've got some big evidence, your case is in deep trouble. And it's a heads up that the judge isn't buying what you're selling, right? Which is going to be a problem later on. And in this case, it was shown to be a problem later on. And at least the prosecutors ultimately recognized that and dismissed the case without prejudice. I'll talk about that in a minute. So the judge says, nope, you didn't meet the standard. He is released. Now the defense is in a very good position. The client is not interested in a speedy trial. So you saw that they've told the speedy trial. They said, take 100 years if you want to prosecute the case. So they've waived the speedy trial rights. They said, take as much time as you want. In the meantime, the defense is going to be beating you up with motions left and right. And they have done that in this case. And they've got all the time in the world to do it. And they're in no hurry. because their client is walking the streets doing whatever he wants to do. So it's very good defense strategy to do that, but it also is telling that they file this motion to dismiss without prejudice. Now, you cannot file a motion, the prosecution cannot file a motion to dismiss for the purpose of gaining time or tactical advantage. There has to be a real legal reason why it is you want to dismiss without prejudice. Otherwise, the judge will dismiss the case with prejudice, meaning you cannot refile. Double jeopardy attaches, and you can't refile the case. It's been dismissed with prejudice. Case is gone forever. So the prosecution has to come up with a real good legal reason, because that judge who already isn't buying what you're selling is going to, you run the risk of having that case dismissed forever. And a person that you believe is a murderer walking free. So I saw in there that they say that they need time to search for locations of the body.
So
And
you want me to put the motion up now?
Sure.
You
sure.
tell me when
Yeah.
you tell me when you're ready, because
I'm ready. I'm ready anytime.
okay, yeah, you nailed it right away. And by the way, again, if you've just joined us, I'm going to answer all your super chats. Trust me, I see them coming up, but I don't want to distract Billy, because I know how he is. He's amazing. His brain starts going, and it's like a race car. You can't once it leaves, the fourth curve in Charlotte, you're not getting it back. Number 18's on its way. Okay, so stand by here. Let me put it up.
Okay.
So I'm going to add to the screen. Okay, and then I'm going to have to do this in pieces, because this is the part that
Right there. The
that you
first
brought up.
paragraph,
Yeah,
which
go
is
ahead and
also
explain that.
so
Yeah.
in. I'm sorry, Chris. You were talking?
No, go ahead. I'm sorry.
Okay. So, Chris, you know this because you're an expert interviewer, but poker players will also know it. It's something called a tell. And in this case, their motion in the very first paragraph discusses probable cause, not in the detail that I discussed it, discusses proof, evident, presumption, great, and posted a bond, and he got out. Then the tolling, the speedy trial, all the stuff that I talked about. So that is a tell to say the prosecutors recognize right up front that there is a problem with their case. And this is what's on their mind. It's right in paragraph 1. The rest of the motion is spent discussing the rules, the law, and the analysis and the argument and the way that they're applying the law to this case. And the reason they go into such detail is because they don't want this case dismissed with prejudice. So they spent a lot of time talking about why it is they need to dismiss this case now, that they recognize that they're acknowledging that there was not this proof, evident, presumption, great. They need to gather more evidence. So they spent the majority of the motion talking about that, with good reason, because they were scared as heck that the judge was just going to kick this case forever. And you know that the judge was on the verge of that, because the judge has precluded a bunch of witnesses that the government needs to prove their case. So you can tell the judge, for some reason, thinks there's a real possibility that this guy is innocent. I don't know the facts of the case at all, so I'm not making a judgment on that one way or the other.
That was the other reason I wanted you here with this audience, because I know you're right down the middle. Go ahead.
But regardless of whether I believed it or not, it doesn't matter. The judge believes there's a problem with this case, and the judge has started to kick witnesses. Now, the prosecution is put in a spot. They can either do what's called an interlocutory appeal, meaning they can appeal the judge's decision right now. They don't have to wait till after the trial, because in prosecution, if you get a not guilty, you can't appeal it, right? So they need to do their appeal now. So they have to make a decision. Do this, what's called an interlocutory appeal, do it right now, or dismiss the case. Or they could go forward, but the judge has already shown that they don't believe that there's sufficient evidence in this case, even to get past a lower standard than beyond a reasonable doubt. In fact, you'd almost, as a defense attorney, you'd almost be in a position where you would go judge alone trial for this murder case, knowing that you've got the judge on your side. Not that the judge is on a side, but you know that the judge is leaning one way and thinking the evidence is not very strong for the prosecution. So they go ahead.
No, so there was. Do you sense when you're reading this and being objective, obviously, because you've not been involved in this as a whole, what's your read of the judge's ruling in relationship to, the scales of justice here? What's he doing? What's he doing as a judge?
Is it a male or female? I don't know. But anyway, the judge. I'll just call this person the judge.
Okay.
What the judge is doing in this case is telling the government, I don't think so. You do not have enough evidence here to get a conviction beyond a reasonable doubt. And if you go forward, you're toast, basically. If Mr. Morphew is in fact guilty, then you've just messed up the whole case and you let a murderer go free. If he's innocent, then you're prosecuting an innocent person, which nobody wants to do. So the judge is showing his or her hand by saying, you guys, your case is weak. Yeah, maybe you can get past 51%, but you're not going to get to beyond a reasonable doubt. And by the way, you've done some things that I don't agree with, so I'm going to kick some of your witnesses. I'm going to kick some of your evidence. The judge believes that they've been playing a little bit fast and loose with the evidence. So some of the witnesses have been precluded as a sanction. That's not something they can't overcome. But again, it's kind of a tell from the judge that the judge thinks this case is not that great.
And that's interesting in of itself because were you successful in getting judges to kick 5 expert witnesses, for the prosecution?
Never.
Zero times.
Well, I mean, I've had them kick witnesses, but not that many. No way.
Yeah. Right. And that was one of the things I thought was really interesting because, these folks are pivotal, in terms of some of the data, collections and that type of stuff and others. But to boot 5 of them, without, I always thought, man, that just doesn't feel right. And then of course, one of the other strategies was, to put the victim on trial. Explain that a little bit about as a strategy, why that sometimes can be a plus or a minus, especially with in today's society and if she's a victim of domestic abuse.
So a couple of things. You've raised a lot of issues. So let me start with this one. So with the kicking the witnesses, the prosecution can also file an interlocutory appeal to deal with that issue if they want to. So they can appeal the judge's ruling on kicking the witnesses. So that's a calculation that they had to make.
So this is what this Elander says.
All right, I'll address that in a little bit. So putting the victim on trial, and this is a little bit complex because really what you're talking about at trial is credibility. Who has the most credibility? Who does the jury believe? Do they believe the lawyer on one side? Do they believe the witnesses on one side? And so what you try to do is ding up the victim a little. If you're a defense attorney, you try to ding up the victim to hurt their credibility, to make them less sympathetic, that will also increase the credibility of your witnesses to show, well, they were a bad person, so, you shouldn't care that much, or you can't believe too much, or depending on what your defense strategy is. Let's say your defense strategy in this case with no body is that, well, they ran off with a boyfriend. Well, you're going to say, well, I'm going to drag in a bunch of people who were boyfriends with this person and show that. And that kind of dings their credibility up. And you're like, well, maybe so, because all you need is one juror, right? Maybe you get a juror going, well, maybe he killed her, maybe he didn't, but, who really cares, because I didn't really like that person anyway. And maybe I would have done the same thing. I don't know. So it depends on your defense strategy, but attacking the victims used to be a lot more popular than it is now. They've come out with a lot of victims' rights bills and statutes. They've even added to some state constitutions the Victims' Bill of Rights, because especially with the old rape cases, they would attack them as just being promiscuous women, and they wanted it really, but then they changed their mind. So they've eliminated a lot of the ability to attack the victim's character, and there are a bunch of rules on character evidence for the defendant and the victims. So depends on your defense strategy, but you can attack the victim if that plays into your defense strategy. I don't know if any of that made any sense or.
Yeah.
All right.
No, it made a lot of sense. And I mean, one of the things that we saw right from the get-go was this hypothesis that she, ran off with, her boyfriend, and believe it or not, had gone to Mexico and a variety of other places. Sound familiar?
Oh, boy.
And right. And all of a sudden, there's this appearance of, well, we don't know where she is and she's not come back, and et cetera, et cetera. They had all kinds of, GPS coordinates and that type of stuff. And of course, I mean, it's a great strategy from defense to take all that stuff on. And then if you can get it booted and kicked, as quickly as possible, that's a great strategy, right? I mean, as a whole.
Yeah, with the right set of facts, yeah. You can also, lose jury. It depends. Each case is different. Thanks, Kathy. But yeah, each case is different. Depends on defense strategy. You also, you can take that too far. If you're a defense attorney or a defendant, and they will wind up hating you for attacking this mother or whatever, and then you can also get spun on you because, I mean, isn't that the logic that Jack the Ripper used?
Yeah.
These people are not moral, so I'm going to kill them, right? So it can blow up in your face.
Yep. Do you think? Well, there's going to be a bunch of questions coming at us here. Do you sense that when you read what the judge said here, that in the very beginning, look, I had a problem in the very beginning, or at least the court had a problem with the evidence that you're putting on in front of us, because a lot of the evidence that was presented initially, the judge commented in his motion to allow it to proceed, was the most amount of, circumstantial / hearsay I've ever read in my career. And then he goes on to, present it about, well, there are, some things in here that are obvious. And so I've got no other choice essentially, but to let it in. But you, the people, are going to have quite some time, presenting this to a jury. And then simultaneously, the defense asked, well, how about if we just rewrite, the affidavit, basically, that the sworn affidavit that the law enforcement officer had submitted, and we'll clean it up for you, Your Honor. How about that? And I mean, that was a pretty gutsy move. Even when I heard about it, I was like, who does that? Who does that?
They're pretty confident in their defense case. And so there is some problems. And if you want to see the best case presented by the government, by the state, Go back to that proof evident presumption, grade those motions, go back to the transcripts of that hearing. That will tell you. And at that hearing, you're going to have all of the evidence that was precluded by the judge. The judge took that into consideration. So even with that extra evidence and witnesses taken into consideration, the judge still did not find proof evident presumption great. And now the judge has kicked a lot of that evidence when you're skating on thin ice, especially if you have some experienced defense attorneys. And I'm telling you, I don't know who these people are, but I can tell you just based on the way that this reads that these are some very good defense attorneys. So you're going to have a problem.
Yeah. So let's just recap for everybody just coming in. We got 1,700 people here now that essentially within the first paragraph, the judge tells them, or the prosecution tells the judge, look, we know there were some problems and we're just trying to save off what we can. Is that a correct recap, or you want to clean that up?
Well, the judge is telling the prosecution that their case is weak, and that in the judge's mind, you can see it in the judge's mind that the judge is not buying it.
But declined to find proof evident presumption. Great.
Yeah, the judge is like, hey, this case is pretty weak. I'm certainly not going to hold this person without bail. I'm going to set a bail, and a bail that obviously was attainable by Mr. Morphew, because he posted the bail and now he's out walking the streets. And so, sorry, I get distracted even by my cell phone going off.
No problem.
So the judge says, look, your case sucks. Go back to the drawing board. And the prosecution, they must have had some horrible conversations and a real come to Jesus meeting at some point to file this motion to dismiss without prejudice. And so I guess the hunt is back on for the body. And maybe they feel like that's really the only thing that's going to save this case is a body. So I don't know.
Yeah. So let's talk about that. We get the body. We've got the body. And by the way, the majority of the other 10 pages on this motion is essentially just foundation for the position that they're taking, right? Would that be a fair explanation? Yeah. So, I mean, I don't want to go through the mumbo jumbo, the legal battle there, but everything is really within this 1-point background. Everything we need to know, the judge put it, or the prosecution put it right up front. Says, yeah, we kind of agree with you now that we take a look at this. We just need more time to kind of look for the body. So we get the body. What say you?
If they find the body?
Yeah.
They're obviously in a much better position. And then you're going to have it forensically analyzed, right, to see. Maybe they can determine what the cause of death is. Maybe they can't, but at least they have a body. So that cuts off she ran off to Mexico or Jamaica with a boyfriend.
Yeah.
Threw another case in there.
Yeah. The reason we're laughing is we've actually got a case just like that. So, but go ahead, finish your thought.
So, but the judges are, there's a very specific jury instruction dealing with circumstantial evidence. It is real evidence. It is evidence that is used to convict people every day in this country. So for a judge to call out that this is a circumstantial evidence case is more than just that, because you can get convicted, and people do every single day, on circumstantial evidence. It is the example that they always use in court is, if you're in the house and you can hear the rain on the roof, and you go outside and you can see all the ground is wet, but you never see it raining. That is circumstantial evidence that it rained, right? You can find beyond a reasonable doubt that it rained without seeing it rain. So you can find somebody guilty of murder without seeing them commit the murder, without even seeing the body. All you need is circumstantial evidence that proves it beyond a reasonable doubt. That is our standard. So the fact that the judge calls out that it is a circumstantial case, that is significant in that this is not a judge who's going to not convict somebody on circumstantial evidence. It means that the judge says this case is weak for whatever reason. Again, I don't know the facts of the case, other than the little bit that I've read about, but I haven't seen the investigation. I don't know anything about it.
Oh, it's a doozy. And there's, in my humble opinion, I said, in the very beginning, I met with the family. I met with Andy, the brother, her brother, because they just didn't feel like they were getting progress. And then we saw some of the video that came out, the officers' body cameras, and he's walking around the house helping the cops out as if it's part of his thing. And I don't know, what that was all about, other than, how many cases have you and I both seen where, you've got somebody reported missing, the cops are there, they think it's suspicious, and you're asking the parties, hanging around, hey, can you go get some bags so we can throw some stuff into it, right? I mean, you would have crucified me on the stand. Am I wrong there?
Yeah, no, you're right. There is a right and a wrong way to process a scene. And at that moment, you don't know, is somebody missing or are they murdered? But if you make a mistake and you guess wrong as the, detective on the street, if you guess wrong, well, gosh, I thought she was just missing. You have seriously hurt your case by
Yeah.
not handling the scene in the way that you know how to handle a scene, how to process a scene. And you will get crucified by somebody like me, just pointing out in your own manuals what it is you did and didn't do right. So,
Right. What did they call it? The Bible? The
the
Bible?
Bible,
Oh,
you know,
yeah. Vernon, right?
yeah,
The
yeah,
book. And so this is, so essentially right from the get-go, and then there were some other things, that quite frankly, there were people on the ground out there that, really smart, were doing some really, cool things. And, then we were able to help. I interviewed some folks behind the scenes. There was some pictures that I took, and others had taken, about this, process of potentially trees being involved and her underneath those trees. We took some cadaver dogs out there. We got a hit on, some specific areas. The brother was right there. I have those pictures of the brother talking to CBI, because it appeared that they had one of those trees under surveillance. And he was quite frankly asked, "How did you find this tree?" And he was forthcoming and said, "Well, we were searching this area over here with the dogs, and the dog hit on it." And by the way, there were 3 dogs, not one. There were 3 certified cadaver dogs, and one of the dogs had, actually was in 3 different, or 2 or 3 different murder trials in the state of Colorado, certified and voir dired, as a qualified handler slash cadaver dog team. And it was that team that hit, that tree. And I kind of, went a little, behind the scenes saying, go. I mean, homicide 101 is okay. We're going to process this area, right? Have a great day. And
yep.
I don't know if it's ever really been done, to be honest with you. I was told it was done, but I didn't see it. But that's just my opinion. It, whatever that means, um,
You get a cadaver dog, a trained cadaver dog to hit on an area, that gets you over the 50%. That gets you enough for a search warrant. So that
Yeah.
should have been processed, sealed off and processed.
Right.
I don't know if that was done or not done, but it should have been, if what you're saying is true, and I know you only speak the truth, so that should have been done.
Yeah. And it was, kind of interesting. And in fact, I posted the trees on my community page. If you haven't seen it, go over and take a look at the tree, and you're going to see a ring around the bottom. Now that I talked to some folks where who are involved in the body farm and stuff. You know what we're talking, Billy,
Mhm.
and that the discoloration could be consistent with decomposition, and this was over a year ago. This was a year ago, and I thought, okay, well, we're good to go. And then I was able to some other things behind the scenes. We produced, uh, every tree that was ever purchased by him in that region for his landscaping company, turned all that over. Andy turned it over to the authorities. And there was a lot of things behind the scenes that were going on from just, good citizens, helping. And so the question is here that, okay, where does he go from here? This is obvious. The court has said, look, you guys have a problem.
Mhm.
And do, is the body really going to make a difference? And then I'm going to start putting some of these questions up um, for you, Billy, to take some legal shots. Are you good to go with all that? Are you?
Oh yeah, sure, sure. I'm good to go with that. Well, so will the body make a difference? Yes, and it'll make a difference to the judge. And so then you can start coming at the judge with some motions to reconsider. If you don't win that, then you can think about interlocutory appeals. So in this particular case, and certainly not in the other cases, but in this particular case, it seems like the body would make a difference. Um, I don't know. I don't know why, but it certainly the prosecutors think it will. That's why they put it in their justification to dismiss without prejudice. Um, but yeah, I appreciate the work that you and the family did to um, help law enforcement with their investigation. That's absolutely great. I'm surprised if that tree is still standing. I,
I think folks are reading now in this motion here. They need more time. That there's 5 feet of snow in certain areas where they believe geographically, and for all we know, right? I didn't get feedback from. I got feedback from the handler because they talked to the authorities. The authorities came down actually.
hmm,
There were 4 or 5 places that the dogs hit, and there was one of these. One of them was behind a house that he was working on by a riverbed, and the theory was that if he had moved her with his bobcat, let's presupposing he's the suspect, okay, and then had he moved her with a bobcat, then there was going to be some of her scent still on that vehicle, and lo and behold, the dogs, the same dog, by the way, uh, at this area around the uh, area that he was working, hit in a muddy area. And the suggestion was, okay, well, if you don't like this cadaver dog, then fine, go get others from, whoever, and
yeah,
bring those dogs down and let them do. So, um, it's pretty clear that some of that also did not get completely flushed out, but I don't know that for sure. So that's just, I guess I should correct myself and don't want to speculate like that. But I did talk to the handler, and and that handler said we were never recontacted. So that just tells me everything I needed to know right then and there.
Yeah. And
Go
you
ahead.
know this, Chris, but I mean, we're not here to criticize law enforcement. We're not here to criticize judges or prosecutors. We're not even here to criticize the people who are the suspects. We're here to help discover the truth, right? So that people do things right and wrong or have a different idea than we do, that's fine. But the answer in the end can't be, oh gosh, we just have no idea. We'll stick this on the cold case shelf. That's never a good answer for a family that has lost a loved one.
Yeah, never.
So
never.
you and I, we do not stop until there's an answer.
Yeah.
Right?
Yeah, that's why they call us Starsky and Crutch. And I'll let the audience decide who's Crutch. And by the way, we've got almost 2,000. One more person. We're up over 2,000 people sitting in listening to us. But if you guys are just joining us, I have to tell you, I have Billy Little here. He is one of the brightest minds in the legal arena today. He's an amazing human being. He's handled over 17 capital death cases. He was an administrative judge in Arizona. He was a military veteran of many years in the Marine Corps, as well as in the Air Force. He retired as a full colonel, and then he came out to, basically help find the truth, seek the truth, no matter what it is, plus or minuses. And that's why I wanted him on tonight. He was not familiar with the case. He's been too busy doing 1,000 other things, but I was able to corral him onto this one. And,
I got to say, Chris, retirement is not what it's cracked up to be. It's never been busier.
Yeah. And you probably recognize him from 48 Hours and other shows where he's constantly called on, because of his skill. He, in my opinion, single-handedly broke Maya Miliete's case into very small puzzle pieces and put them back together. And one of the main reasons that Larry Miliete is in custody today is because of my friend here that you folks are listening to. And let me tell you, if we're headed up to Michigan, but on another case with D. Warner, but and by the way, I'm hoping to broadcast live from up there this weekend. So come back, everybody, because quite frankly, that's another interesting circle. But Billy has been up there, and I'm not going to say anything, but you'll see. It's going to be pretty.
I got a special Mother's Day gift.
We have a special Mother's Day gift for you, and it's the first time, quite frankly, it'll ever be done on YouTube. So we're going to let that happen. Okay. So that said, I'm going to put some of the questions up here. Let's see here. Okay, stand by. And thank you, by the way. I'm going to also just scroll through here some of the new members here. And thank you for joining us tonight. Mod, so great to have you on the team. Cotton Candy 65, love it. Okay, Carrie has a question here. Carrie MC, will the motions from this trial carry over to a new trial for Barry?
The rulings will carry forward. The prosecution, I mean, whichever side wants to, can file a motion to reconsider. But yes, they are, for the time being, that is settled law. Now they can, like I said, they can file interlocutory appeals. They can file motions to reconsider, but you're swimming upstream. If the witnesses have been precluded by a judge, you've got to try to convince either that judge or a new judge to change that position. And that is a very difficult hill to climb.
Okay. Thank you, Carrie. I hope you have a blessed day. Appreciate that. Okay, so Amy Hill says, why does it take so long?
Oh my gosh. Well, I can tell you that from the defense side, when you're dealing with a murder case, your job, your responsibility, according to the ABA standard, American Bar Association standard, is you must reinvestigate the entire case, regardless of the evidence, regardless if your client confesses to you, confesses to the police, tells you not to reinvestigate the case, you still must, as a criminal defense attorney for a murder case, you must reinvestigate the entire case. There have been we've had a history of, and it doesn't happen a lot, but it does happen, of innocent people being convicted, and we want to avoid that at all costs. So we need talented, experienced criminal defense attorneys to make sure that we're not getting innocent people convicted. So it does take a long time. And in capital cases, it takes even longer. And the amount of money that the government spends prosecuting these cases and defending these cases is enormous.
So Kaylee says, "Oh no, wait, are you saying that it's going to be difficult to recharge him? Please tell me I'm hearing it wrong."
No, they're past the preponderance of the evidence. They're past the 51%. The judge never said they fell below that standard. They could recharge him tomorrow, but they're going to be in the same boat. So they're not going to do that unless they fix whatever problems they have in the case. So if he is the guilty party, and again, I don't know, I haven't seen the case, but if he is, they will not give up. At least they're not going to give up right now. So if they believe him to be the guilty party, they will continue to investigate and look for evidence to get past the hurdles that have been put in front of them.
Okay. So in the statement, we know where her body is, question mark. What do you think of that the prosecution put into the motion?
Well, I don't want to say, because I don't want to help the defense, because I don't know if he's guilty or innocent. I could tell you what I think, but if I tell you, that's going to help the defense team, and they've got good defense attorneys. They know what that means. And later on we can talk about that, but I'm sorry, I'm going to dodge that question because I don't want to help somebody who may or may not be guilty. I don't know enough about the case. So.
Okay, fair enough. Sorry. Fair enough, Billy. Okay, so Vet Girl says, another veteran, by the way, thank you for your service as always. Does the DA have to go back to grand jury for another indictment, please?
No.
Okay, so they can just rock and roll, right?
Yeah.
Would it keep it real asked, this does not fall under double jeopardy, correct?
Correct. Jeopardy has not attached. So now
explain that. Break that down.
Okay. So jeopardy attachment. So let's say you go to trial and you win, or you get to trial and you've sworn a jury in, and then somehow you move to dismiss the case, or the case is dismissed. It's more difficult. At some point, jeopardy attaches, usually when the jury is sworn in, but even in that, mistrials are granted. Double jeopardy doesn't apply, but if they're found not guilty, obviously double jeopardy comes into play. But sometimes even double jeopardy comes into play during a mistrial. If the prosecution has caused the mistrial, or it appears as though they're doing it for some sort of tactical advantage. But the short answer is, at this point, there's no double jeopardy. Okay. So I hope I wasn't too confusing, Boston Strong.
No, that was awesome. So do you think they will be diligent? So there was some DNA. So actually it's mixed DNA on her dashboard area near her glove box. And it comes back to multiple, hits with variety of different, targets, 2 of them or 3 of them being RSOs. And so of course the defense has tied that into, you see, there's your guy. Explain that strategy and what you've done in the what your thinking
So,
is.
so DNA is, if you have two contributors to DNA, so if, let's say you have a victim and a perpetrator, you've got two people. You have two known samples of DNA. So you match the alleles. Again, this can be very complicated. So I'm trying to make it as simple as possible. But the more people's DNA, the more alleles you add to that DNA mixture, the more difficult it becomes to exclude people or include them, right? You can say, well, they can't be excluded, and then you put a percentage on it, and the analysts will put a percentage on it. But once you get down to, I've seen DNA where it's like, this is, you would have to be 1 in quadrillion people to not be this particular person. And I've seen it where, well, this is 1 in 1,000. So you get a full range of that. And I think I saw somebody put up that there's partial DNA. That makes it even more difficult. So let's say you match, I match one of the alleles or two of the alleles or something. And then you say, well, yeah, well, so do 5 million other people in this country match those two alleles. So it can be very complicated. And the more people's DNA, the mixture you get, the more complicated it gets. If there's somebody else's DNA that cannot be excluded, that you can not rule out them as a suspect or a person of interest, now you've got a real problem. And it sounds like, and again, I don't know the facts of this case, but it sounds like that's where the defense was going. You can't rule out this particular person who is also, a bad dude. Did I answer the question, Chris?
Yeah, no, you're awesome. That was beautiful. Appreciate that. The questionnaire, Cindy says, how long before they can take him back to court?
They could take him back to court tomorrow. But again, they're going to be in the same position they are today. So they need something new, whatever that is, or they need a new strategy.
Okay, so here's here's more of a comment from L. Anders. The case is weak because DV history evidence isn't allowed and witness not allowed to be classified as experts. Interesting.
So if there's a DV expert, I'm just trying to read into it.
Yeah.
Apparently there was a DV expert who was going to testify. And did the judge not allow that expert to be qualified, or did they not allow that evidence to be admitted at trial? Is that what's going on?
Yeah, both.
Okay. Yeah, you got a problem. If your case this was a cycle of violence, this was a classic escalation in domestic violence, and that was going to be your theory for prosecution, yeah, you got a problem with your case. If all you can do is show the circumstantial evidence at the time of the offense, that's going to be, as Anders describes, that's going to be a weak case.
So this question here from Seeking is more evident. If more evidence is found, like body DNA, can Barry be rearrested on the same charges?
Yes.
Okay.
Good question. Yes.
Yeah, that's a great question. Thank you for that question, Seeking Justice. That's awesome. Okay, I'm going back here looking through a couple of more. Hang on, there's a bunch more. They're coming in.
You got a really smart audience.
I tell you, we've got the best. I mean, every YouTube channel has the best, of course, but I'll tell you, we've got they're smart. And not only that, I mean, and we've got a treat for you. Again, we're not going to tell you, but you're going to want to be here on Mother's Day. It's going to be absolutely, not only amazing, but it's going to be fantastic. So we just answered
first ever on the internet.
Ever. Let's see here. Kate does crime. I think the judge went so hard because it was apparent that they were being sneaky with evidence, like the dog handler. They didn't ask him for a report and had their own deputy write it. It was not what happened. That's an interesting.
You got to be, when you are in my opinion, on both sides. But when you're prosecution, police, when you're representing the government, you have to be 100% above board. There is no hiding the ball, hiding cards. There's none of that. You have to just be straight. And if you made a mistake, just say it. It's okay. We all make mistakes. But do not try to hide evidence. Do not try to change the facts of a case. That will blow up in your face. And I'm pretty sure that you and I, Chris, have worked on a case like that where they
Yes.
lost, hid, and lied about evidence, and it didn't work out well for them. So
Yeah.
I can't say it enough. Just be honest. The most dangerous police officers are the ones when you put them on the stand will say, yeah, I guess I could have done it differently, or I guess I could have done it better, but I did it the best I could. And the jury's like, yeah, why are you giving him such a hard time? He did his job.
Yeah, and it's so simple, right? I mean, it's
Yeah.
like you just put it all out there, and you guys can argue over it.
Yeah. It's
and
just,
then
but it's embarrassing when you get caught making a mistake and then you're publicly called out for it. But man, when you're in those positions of trust, you just have to say, yep, sorry about that.
Yep. So this one is more of a, why wouldn't GPS, telematics, and cell phone signals be admissible?
Yeah. So I did not read the motions on that. I did not hear it. I do not know the evidence. So this is 100% speculation on my part. But I think it goes back to what the judge believes about this case. The judge must believe that there's a real possibility this guy did not do the crime. And when you get in those situations, you're going to get more favorable defense rulings. So, but again, that's total 100% guess because I haven't read the motions. But yeah, maybe there's a technical reason for it. Maybe the defense had an expert. I just don't know.
Okay.
It's a good question, though.
Yeah. Well, Albie, I say that you said you sent a question. Can you? I'm looking for it, but can you send it again? And just highlight it so I can grab it. I'm tagging everybody's questions, or at least, the ones I can catch. And thank you so much, everybody, for being patient with us here. This is great. I mean, as you can tell, I've got a dear friend here who's an amazing legal mind. So there's a case in England here, Billy, from says we had a case in England based on circumstantial, phones turned off, body never recovered. The father was convicted.
Yep.
Did you ever have one? Did you ever work a caper like that?
Oh, yeah. No, there's a lot of murders. Exactly what he said. Who was that gentleman, by the way?
I just dropped this question. I apologize.
Okay.
John,
That's
from the UK.
an excellent point. He's saying exactly what we talked about earlier in this conversation. Yep. You get a strong circumstantial case that it's raining outside, and guess what? Everybody agrees it was raining, and you committed the murder, and you're going to pay for it. So, yep, it's a very good point.
So let's see here. This is moving. Thank you, everybody, for your patience again, and for being here tonight. And just to let we're cooking through here. And here is another counselor. Who is brilliant. Let's hope the forensic evidence to connect him to will bolster their case if they find a body. Yeah, that's a great statement.
Well, finding the body fixes a lot of problems for them, right?
Yeah.
We know that she's not in Mexico. If they find the body somewhere where he was working, now we've got to tie to him and the landscaping. Again, that's presuming he's guilty. And I have no idea whether the guy's guilty or innocent. I have no idea.
Well, and which leads to the next question. It's a good segue. Will he be allowed to move? Yeah.
Yeah, he can do whatever. He's free, just like me and you.
Yep.
In fact, I had a friend with a case where a guy was charged with a capital murder. They did the same move. They dismissed only to refile. They dismissed, and this guy said, if I were you, I would head for the hills, which he didn't do. He spent that weekend partying. On a Monday, they refiled and rearrested him and convicted him. So he can move and do whatever he wants. He can go to Jamaica or Mexico or wherever he wants.
Yep.
Um,
Yeah, but
so
there's going to be
there's a flight, but here's the danger
there's
in that.
flags. Yeah.
Well, no. There's you get a flight instruction. So when you're doing your closing arguments for the government, the jury gets an instruction that says if a person flees, you can use that as an indication of consciousness of guilt. So if he takes off and heads to Mexico, he's just hurt his own case. Now you get a flight instruction. Maybe that's enough to get the judge to go, okay, there's something fishy with this dude.
Can he
What
be
would it take
rearrested? Right? Or what would it take to get a different judge?
You could ask the judge to recuse himself. You could file a motion to show bias or something. It would be, at this point, I mean, you want to get a different judge because this judge isn't buying what you're selling. That's not a good reason to get a different judge, and no court in this country is going to allow you to do that. Now we're almost into change of venue, sunshine and daisies. Do you want to file it in a different location? You want to get a change of venue and then get a different judge? You're going to run into the same problem. Somebody's going to look at you and go, now you're playing games with the legal system. That's only going to make it worse for the prosecution.
And so there were two counties, Chaffee and Fremont. Would it be refiled back in Chaffee County again, where it was just kicked?
I'm assuming it's a state charge, like it's a state law that was violated, and so the jurisdiction may or may not be an issue. Again, I haven't seen the pleadings and read any of it. So if jurisdiction is an issue, there would have been a motion to dismiss for lack of jurisdiction. I didn't see anything like that in there, so I don't think jurisdiction is an issue. I didn't see anything mentioned about change of venue for some reason. So I don't know where it would be refiled because I don't know the case.
So are there other charges pending because he had some tax evasion stuff? It looked like he was kicked just for the homicide here. So could they? Yeah, I mean, they can still prosecute him on the other stuff as long as they didn't enjoin him into the original charge sheet, because the judge kicked him, from basically everything he was arrested for. He said, "Have a great day." Essentially, right, Billy? Am I wrong there, or what do you think?
Yeah, I don't know the case. So if there are other charges, I wouldn't have an answer. You would know more about that than me.
Yeah, no, he's there. So here's a question here. Do you think this case is similar in many ways to D. Warner? Both dynamics. Interesting. We're going to answer that question coming up. Seriously, Billy has been on the ground there, and we are he's got some amazing stuff that's coming. And we're going to have a Mother's Day special. So there is a service though for her this weekend, and
Yeah.
go to my community page. I have it up, and you can see the flyer for her over there. Okay.
So these domestic violence cases, I've had it up to here with these guys who just beat their wives, beat their girlfriends, kill their wives, kill their girlfriends. I'm sick of these domestic violence cases. So there's a lot of reasons why to have a nice, strong message on Mother's Day. But this domestic violence it's got to stop.
Do we think his girlfriend will turn on him? I'll answer this one, Bill. Once he starts cheating on her, if she doesn't, she needs to get out of the cycle. because I hope she does. I hope she, gets a pen just like Suzanne. Or Suzanne, the victim had a secret spy pen, and she put it in his truck. It was pretty intuitive. And of course, she had a diary that she was keeping and sending messages to her best friend. She was supposed to attend a wedding for her best friend's daughter, never showed up. So, and of course, the boyfriend said, or the husband says, yeah, she's out, riding her bike, no return. And at first, it was she was attacked by a mountain lion. So we got hold of some experts in mountain lion preservation. Basically, there's only a few of them in the country, and we got hold of the two that handle that area. And it was no, no, not the mountain lion at all. And a lot of folks are just physically, mentally, emotionally drained from this particular case, and more so this guy. But it is what it is. Is there any connection that he could flee? Let's hope not. Billy just answered that. If he does, it shows a consciousness of guilt.
Yeah, that's if he flees the country, that's good for the prosecution. That's good for getting him convicted. Yeah.
This was a question here. If he gets arrested again, can you still use the original charge sheet, or do you got to start all over?
They could charge him with whatever they have probable cause to charge him with. So the current charges have been dismissed without prejudice, meaning they can refile those charges or any other charges they have probable cause for. So they can make the charge sheet look like whatever they want, as long as they have reached the 51% mark.
Okay. Let's see here. Got a couple more questions. Asking for immunity wasn't enough, Elizabeth. Not sure what that means, Elizabeth. Can you clarify that a little for me? This one, how would DNA evidence in a glove box be connected to her disappearance? Well, if there's any kind of DNA in the glove box, you want to eliminate that as, who the donor was, and then eliminate it through investigative processes in relationship to why would this person's DNA be in that vehicle. But of course, if it's a mixture, which in this case it was, and a variety of other potential donors, then, you have to just, beat the street and talk to people one-on-one, and identify, to check the box that you did that. So when you turn it over to the DA, and they turn it over under what they call Brady, all this information. Explain what Brady evidence is, Billy. That'd be a good one for folks to understand, because there was a lot of Brady discussion here from the defense.
Yeah. So if the government possesses evidence that could be exculpatory, meaning that it has any possibility to show that it could prove innocence, you can't hide it. You can't fool around with it. You got to disclose it. So let's say examples of Brady evidence would be, let's say the main investigating officer has been found guilty of perjury, right? And the prosecutor tries to hide that. Well, we're not going to let the defense know that this officer is a known perjurer who will lie on the stand, and then they put him on the stand. So they have to disclose that. If there is DNA evidence that is exculpatory, meaning that, maybe it shows that there's somebody else who's involved, you can't hide that evidence. You got to give it to them, right? And that's how we want this system in this country. We want the government not to hide evidence that would tend to show that a person is innocent, because they are in the position of seeking the truth, not seeking a conviction. So Brady was a Supreme Court case, which that's kind of the layperson's explanation of what Brady does. But you can't hide evidence. And we wouldn't want to live in a country where we allowed our government to hide evidence that shows that we were innocent. Right. So, and if that happened, and I don't know if that happened in this case, but if that happened in this case, that's a big deal. That's a big no-no. And that's not right for Mr. Morphew. That's not fair to him.
So here's Elizabeth says, Barry asked for, and thank you for reminding me of this. Barry asked an investigator for immunity if he paid his whole life out there. That's where one charge came from, influencing an officer. Yeah. Thank you for reminding us about that. There you go. This
It's
one,
whole
I'm
life
not.
insurance or what? What's she talking about? If he paid his whole life insurance or paid his whole life? I don't understand.
Yeah, I don't know. Don't know.
Elizabeth, give us one more shot. Don't judge us.
So this one here, the Bible group, Code 33 said Barry free, right? No,
I don't
the
know what Code 33 is.
emergency traffic only. And so I don't quite understand what you mean by that, but Barry's only free on the outside. He's not free on the inside. Because Suzanne's still missing. And if Code 33 emergency traffic means anything to him, then the one thing about this is this will never go away. Ever go away. What do you think, Billy?
Well, I can tell you this. I've dealt with a lot of murderers, as have you. And there is a lot to be said with confession cleansing your soul. The best night's sleep that these people ever have is when they finally plead guilty or found guilty. They confess what their wrongdoing is. That is the best night's sleep they had since they did what they did. So if you want to sleep in peace, if you want to have the sleep of the just, you will have it after you confess your wrongdoings. And I'm not trying to be religious about it. I'm just telling you from a practical standpoint, I have seen it. People are tormented. And then when they are finally caught and they finally are able to exhale, to breathe out, to let go of this burden that they carry with them, that's when they sleep the sleep of the just. And it's a real thing. I'm sure you've seen it, Chris, but what a relief I see in these people when they finally are able to say, okay, you got me. I did it. And then they lay their head on that pillow at night and can finally sleep.
Yeah, no, and those that didn't do it, you also see that. I mean, I had, we've both had many cases where it's like, no, this person didn't do it, and I'm convinced of it.
Yeah.
And it's our responsibility, and it's the system's responsibility to prove that they did not do it. And then you just present that before a jury and let them decide, or if you can get them all before that, it's what they call 849B in California. Anyway, that's the penal code section for unarresting somebody. And that's your responsibility and your duty as a sworn law enforcement officer from an investigative position. And same with an attorney. They take an oath to seek the truth for justice, period. It's all about the truth, whether we like it or not. I mean, it's just the way it is. I mean, so here's Elizabeth. She had autocorrect. Thank you, Elizabeth. It wasn't necessary for the 5, but thank you so much. But if he laid his whole life out on the line, can he get immunity? That's what he asked LA. So there was a part in the interview with him where he says, if I tell you everything, can I get immunity, basically?
Yeah. Boy, that ship has sailed, unfortunately. But that would have been a good, Chris, you would have had a field day with that.
I would have had, that would have been a lot of fun.
Yeah. Unfortunately, that wasn't handled, I guess, handled in a way that you would have handled it, Chris. Because if somebody makes that statement, you're off to the races, right?
Yep, and I give it to you, and we hit the yard together. We hit the sale. Okay, so I've got a couple. Here's some great statements for you, Billy, and this is, and the guys and gals, thank you so much for supporting him. He is an amazing human being, as you can tell, and I've always been honored to call him as a friend. And not only that, he's a warrior. He was
Don't don't pump me up too much, Chris. I don't like that.
no, okay. I know
Let's just be
Kosovo, Afghanistan, Desert Storm. I won't go there,
yeah.
but he's a warrior, and so is his son too, by the way, who's serving in the military. And I love our veterans, you know that, guys. But here are some folks here. Thank you for sharing, Arctic Cat. Uh, thanks for your knowledge, Cheryl. Um, Fantastic Moonlight View. Let's see here. Amy says, "Wow, thanks for the explanation. I didn't know that. What a lot of work. Thank you." Um, let's see here. Love the interview room. Thank you so much. We're grateful for that. If this trial goes to, if this goes to trial, could it be the same judge? Great question.
Could be. It could be the same judge.
Yeah.
If it goes to trial now, it more than likely would be.
Yeah.
So, well, listen, this is, tell everybody to tune in on Mother's Day. We're going to have a special Mother's Day gift for them. And
Here's one more coming at you.
protection order still valid. Is there an
Yeah, there
order?
are protection orders for witnesses.
Oh, for him to stay away from witnesses?
Yeah.
Yeah, they're in effect until they either expire or a judge throws them out.
So they're still in effect.
Yeah, I haven't read them, but I didn't even know they had them. But yeah, if they haven't expired or a judge hasn't thrown them out, they're still in effect.
Yeah. So those of you who are witnesses and who've been, tracking, what kind of man would shoot chipmunks? Yeah, so he killed.
What?
Yeah, he killed a lot of chipmunks in his time, and then he'd skin them, and he got it down to like 32 seconds. He could get them. So, okay. So Mother's Day, like Billy said, we want you. We have a special Mother's Day presentation coming. First time on the internet, quite frankly, and you're going to absolutely love it. So Billy has been on the ground assisting with the D. Warner's family. Want to give you a heads up on that. I'm going up there. We're going to be together, and we've got a whole bunch of stuff coming. But quite frankly, I'm not going to tip my hat too early because he's done so much work, and it's going to be great. And like we mentioned before, we met up there with the homicide task force working on this. Good guys, good people. We wanted to we basically are running with the family, alongside the family. And so Billy has been doing neat things there. Update on Maya Miliete, still going strong. I talked to Mary, Chris, and Richard recently. They're in phase 2, waiting for um, uh, the upcoming hearings coming in. There's a prelim and a variety of other things. So Freemasonry set Barry free. Okay, Bible Group. Thank you so much. Got it. Go.
Chris, I got to run. I'm sorry. It's been
You're
great.
out. Billy,
I love you.
I love you. Thanks, buddy. And guys, stay on here, and we'll keep moving. Thanks, Bill. See you in a bit.
Thank you. Bye.
Was that guy amazing or what? Was that Billy is he is so humble and so informative, if you can't tell. Uh, he's just an absolute amazing guy. And that's why I wanted him on here tonight, for you folks to, for us to break this down a little bit deeper. There's, so many great things that he brings to the table, and I've been so honored to call him a friend. We also want to tell you how amazing you are, each and every one of you. You're fantastic. Don't give up. Don't give up on this case yet. Okay, don't give up on this case yet. Let's pray and hope that we get lucky. Okay? There are some things that obviously many of us feel and think, and it's important that it's for us to feel and think those things, but at the same time we have to make sure that we maintain a classy and gracious position here. And one of the things that we talked about behind the scenes, that I don't think anybody's mentioned. Everybody was saying, well, he's going to go out and start suing and all this other things. Let me tell you something. That'll be the worst thing he'd ever did. And here's the reason why. Because every attorney that represents every person that they sit in a room will get a shot at him and in a deposition. And that will be brutal. That would be brutal. So that would be actually detrimental to anything at this point to try personally. But so there you go. So I have not talked to Andy yet. I wanted the dust to settle, and because I know there's a lot going on with their family right now, but it's not over yet. Let's just keep this. Let's just hope that they follow up on some things that were pointed out a long time ago, and let's see where it goes. Right, guys. Okay, so it's been a great evening. Let's look forward to this weekend. I'm headed up to meet Billy up there with Dee Warner, and we're back on the road again, like I mentioned. So we're not done. We've got a lot going on with Summer, with Michael, and now that we're up on the road, we're going to hit some stuff over the summertime here and continue to bring you some quality content. Thank you guys very, very much for always being with us and supporting us. Hit that like button, hit that share button. Let's make sure that we get Billy all around the world. Okay. So until then, continue to be good to each other. Take care of each other. Have a blessed next couple of days. And I will see you on Sunday evening. Okay. Thanks a lot, guys. See you in a bit.
Hard working every day, I'm stressed out 24/7, babe. No timeouts, wish we could fly away. You and I go to our favorite place. Oh yeah, make special memories together. I'll be your company now and forever. I say we fly away. You and me go to our favorite place. Feeling the sun on my face in Hawaii. With you, Hawaii. With you, Hawaii. With you, Hawaii. I need a summer breeze, some fresh air to put my mind at ease. No cares. You wanna come with me? Me and you go to our favorite tree. Are you ready now? We jump on a plane now. We're taking away. Yeah, we're taking away. Don't hesitate now. We're taking away. Yeah, we're taking away. We'll never come down. We're going away. Yeah, we're going away. facing a wall.